Okay, let's get into the Sixth Amendment, effective assistance to counsel. Okay, that's where deprivation of rights starts. And that's how it's so easy to cite a conspiracy against rights under the color of law. Okay, so I told you this is all you got to say right here. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counsel for ineffective assistance of counsel, themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct and the Code of Judicial Conduct. Failure to report misconduct is misconduct. Failure to report misconduct, just as well as failure to enforce one's constitutional duties as prescribed in the rules and the codes. The lack of the requirements of the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist. A deprivation of rights in its entirety. It clearly shows the judge, the attorneys in my case, committed a conspiracy against rights under the color of the law. Prohibited, the willful deprivation of rights. Privileges are the immunities under the color of law. So no immunities for doing this. Okay, no one can willingly and knowingly deprive you of any of your constitutional rights and claim qualified immunity. Look it up, it's on the net. Prohibits conspiracies to injure, oppress, threaten, or intimidate any person in free exercise of enjoyment of any rights or privileges secured by the Constitution or laws of the United States. I trust you would live up to the oath and show competence, diligence, in expediting litigation, as I have meritorious claims of contention. So I strongly stress reporting professional misconduct and maintaining the integrity of the profession. I trust communications will be made for ethical violations, and every penalty will be imposed in the public interest. As trustees, this is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. So people, feel free if you want to stop by Legal Forum and copy and paste that onto your form. You can Google conspiracy against rights complaint form, and it'll take you to a few civil rights divisions, a couple different government agencies. And a young lady told me she was filing with the Department of Justice, and she needed to say it in 500 words or less. And that's about the best I could come up with. But it says a whole lot if you know the rules and the canons. That's why I always stress everybody to learn the rules of professional conduct and the Code of Judicial Conduct. And that doesn't happen in court, so it's an easy win for you. You just got to learn. Print them out. And they're on the internet. You can look at them every day. You know, when I first found it in 1979, I read it every day, a couple times a day for months. I read it once a month now that I can, because it's on the internet. I'm always looking for these changes and why. It's rarely in the public interest. It's, for the most part, in the interest of the bar, because more and more people are finding out about this. And that's illegal. Everything they do, all lawyers and judges are public servants, no matter who they work for. It's required they do what's in the public interest first and utmost. Every public servant, I did a video on it, every public servant, from the police to the president, required to put the oath first. The oath always comes first, and maintaining, there's violations for violating the oath. Look up violations for violating the oath. I also did a video on putting your loyalty to a politician before the oath. That's strictly prohibited, and there's penalties for that. But anyways, you could use that, and that'll basically say none of this happened. Okay, there's a lot of stuff here. And I use this to beat a lawsuit against me and my dad. We were both getting sued for the same thing. I lost in criminal court, went to prison, got out, and civil court, they waited to get the judgment from criminal court and use that, and they thought they had a hands-down win. But I used what was said and done in criminal court to beat the case in civil court. I proved the case was fraudulent, frivolous. And it's because nobody wanted to use any evidence. They were just going my word against hers, and they took her word on everything. Injuries, all the stuff she said she went through, but was easily disproven by the hospital reports, police reports, all her different statements, which was there was about a dozen. There was quite a few. But they chose only to use one in criminal court and a totally different one in civil court. And that's how I won. And the judge didn't want to hear nothing, so we went to trial, and he thought I agreed upon, just going by what they were going by, my word against my ex-fiance's. And the judge was pretty loud about it. And he didn't want it on anything I was going to say on the record, because I was citing the rules and the codes, but in a nonchalant fashion. I wasn't deliberate and direct. Okay, so when we went to go to trial, I walked out there and I used the canons, the Code of Judicial Conduct. Okay, so canon 2. Okay, I didn't read this part. A judge shall perform the duties judicial office impartially, competently, and diligently. So I just said Canon 2, Rule 2.6, ensuring the right to be heard. A judge shall accord every person who has a legal interest in the proceeding or that person's lawyer the right to be heard, or according to the law. Your Honor, I am here pro se, and I have the right to be heard either way. And the judge just looked at me. I said, judge shall perform, Canon 2, a judge shall perform his duties, judicial office impartially, competently, and diligently. Rule 2.15, responding to judicial and lawyer misconduct. He called for a sidebar. Whole bunch of lawyers and him shot out of the court. Went into the judge's chambers. And eventually called me in there a couple hours later. And they made an agreement without me that they would file a voluntary non-suit. So if they didn't file within a year, they couldn't refile. And the judge should have filed, that should have been dismissed with prejudice. Everybody should have, what it said there, should have reported each other for misconduct. They should have reported everybody in criminal court for misconduct. But they didn't do that. That was their legal obligation. I threatened to file complaints against with the ARDC and the Judicial Inquiry Board, and they laughed it off. In the end, they said, yeah, it's easier to get a cop to arrest a cop than basically break the code of silence here. That's all I was doing, breaking the code of silence, and I'm still at it. That was 30 years ago. And actually, I started even longer than before that, because like I said, when I first read the rules and the codes, that was back in '79. So the judge didn't want to hear all this, okay, because that's what I would have threw at him. Because you violate one canon, you wind up violating multiple canons. You might wind up violating multiple rules within the canons. Okay, canon 2, judge shall perform his duties impartially, competently, and diligently. Quick, fast, in a hurry, right? He didn't give me a right to be heard, shot me down. So I said, okay, we'll wait till we go to trial, so that way it's on the record. So I decided to put the Code of Judicial Conduct on the record, put him to task, challenge him to live up to the oath. This is violating the oath. There's penalties for violating the oath. This is deprivation of rights. There's penalties for deprivation of rights. Each one of you could be charged for deprivation of rights. And considering the fact that nobody reported anybody for misconduct, this is a conspiracy against rights under the color of law, which can be easily stated or squashed by getting the government to come at them with a RICO Act. This is a RICO Act, so I told you about that. So if you want to look up the RICO Act, you'll find it. When you file your complaint, you could use this, what I put here. Okay, and you could also throw that on a whistleblower complaint. When you file a complaint against a judge, just put Code of Judicial Conduct complaint form. Okay, and it'll give you that. And you could slap this on that. Okay? Oh, you don't have to throw in the cannons because, like I said, they'll limit to what you can say, but you're going to have to be ready. You're going to have to be ready, okay? I mean, you got to practice this. I mean, you're going to the prom with, your high school crush. You don't want to feel embarrassed, so you practice and learn dancing and whatever it is that, and I mean, you got to go at this with lust, okay? But they drove me to court. But my dad, I got a phone call from my sister, and she was cussing me out. They're gonna lose everything. The insurance company dropped you. They didn't notify me or my dad, but they got a declaratory judgment, I think it was, but saying that I was in some type of rehab or something, psychological issues, and I didn't tell them, and so they didn't have to pay for my attorney, which was a lie. They didn't notify me or my dad, and I wasn't in therapy or nothing like that. But anyways, so my sister called me, so I got my copy of the Rules of Professional Conduct and the Code of Judicial Conduct. Okay, this is going over the preamble. So I went over it with my dad, and I told my dad to read this. I gave him a copy of the Rules of Professional Conduct. So I told him, read it. So he was getting all hyped up reading this. Okay, many lawyers' professional responsibilities are described in the Rules of Professional Conduct. Okay. So you'll read it. Once you read it, you'll find out. I mean, it reads like a Boy Scout handbook, but if there was any Boy Scouts in the legal arena, it'd have to be me, and I'd be the last one. Okay, so my dad, he was getting mad after reading the preamble. Preserving for abuse of legal authority is more readily challenged by a profession whose members are not dependent on the government for the right to practice. That's you. Okay. So anyway, let's get down to the rules. Okay, so I called my dad was reading over the rules, and I had them printed out, so he was able to read out every definition for each one of the rules, and I was taking them off. So I got them good and hyped. When I first got there, I'm not bilingual, but my dad is. His first language is, he grew up speaking Spanish. He grew up in Mexico. And no, he's not illegal. He got his papers, all that stuff. And actually, they changed the laws to where after he became a citizen, they says, oh, well, the laws changed, so you got to do some other stuff. So he had to do other stuff, you know. And then they said, okay, you're a citizen again. And then he had to go again. The last time he went, they asked him, how long you been here? He told them. They said, you get married? He said, yeah. You have kids? Yeah, 7. He said, you have any grandkids? At the time, he only had 13. He said, you've been here too long, you know. Yeah, I'm retired and got a pension. But anyway, so I got my dad's lawyer on the phone, and my dad, first he started out in English, and then he's well-read in English. It's just his enunciation skills had little to be desired, you know. His proficiency was lacking what was necessary to communicate what he wanted to his lawyer, so he went from English to Spanish, or Spanglish to Spanish. Anyways, so I called his lawyer, you know, and I told him I said, yes, I'm sitting here with Mr. Casares, and I thought I should call you because he seems to be a little upset. And we need to solve this issue expeditiously. Excuse me, who are you? I says, the opposing party. I'm sitting here right now with Mr. Casares, and he's reviewing the rules of professional conduct. Excuse me? I says, yes, he's reviewing the rules of professional conduct. I said, fairness to the opposing party. You know, but I thought it would be diligent, you know, to communicate the litigation in the case. You know, I was expediting litigation. You know, I didn't know who you were, and there was a lot of important factors being brought up, and that was the lack of diligence, communication, confidentiality of information, conflict of interest. Client with diminished capacity. Mr. Casares, after reading the rules of professional conduct, clearly stated he was a client of diminished capacity because he doesn't have the legal knowledge to make an informed decision to give informed consent. He says that legal knowledge is that equal to what you or I might have. And he said, excuse me, and I says, and you know, and I know there's no way for declining or terminating representation because he has meritorious claims and contentions about your failure to expedite litigation. Everybody's failure to expedite litigation. At this point, there was a criminal trial. This civil trial has been going on for a while. I said, so you see that he does have meritorious claims and contentions. I swear was the candidate towards the tribunal. Mr. Casares, excuse me for a moment. And then I told the lawyer, was saying, what is he saying? I'm not sure what he's saying. I'm not bilingual. Are you bilingual? He said, no. I said, well, I'm not bilingual either. I was born and raised in Chicago. You know, where I grew up, it's rare you heard anybody speak Spanish. You know, so my dad's pointing at rules, and he's yelling, you know. So he starts talking about misconduct. He's pointing at misconduct and reporting professional misconduct. And so I pointed this out over the phone. That he's pointing at it. I don't know what he's saying, but he's pointing directly at misconduct. And then he's going up and down. You know, he's pointing at everything. I said, so I strongly suggest, I says, you what I do, file a motion to dismiss separation of judgment. We'll start with that first. It'll be easier to get a motion to dismiss. He says, on what grounds? I says, based on inconsistent testimony, based on perjury. I says, I gave Mr. Casares a copy of the hospital reports, which clearly shows, what was stated in the lawsuit can easily be misproven. That's disinformation, which that is illegal. I says, it's easy to prove deprivation of rights just by the rules of professional conduct alone, yet alone with this exculpatory evidence. So I strongly suggest, excuse me, Mr. Casares, excuse me, are you Mr. Deco? He said, no. I says, I don't know what he's saying. He keeps throwing a lot of pinches out there. And he's referring to Mr. Ben Deco. Are you Mr. Deco? No, you're not Mr. Ben Deco. Are you Mr. Cone? He's referring to another gentleman, Mr. Cone, a Mr. Marty Cone. Are you Mr. Marty Cone? He said, no. Well, listen, I got to go. Mr. Casares seems to be having a difficult time here. He seems rather boisterous in a language that I don't understand. So I'm going to have to wait for him to calm down, okay? So I strongly suggest you get on this. Mr. Casares is pointing towards expediting litigation. So he's already gotten the gist of the legal obligations of lawyers and judges. All right, you have a good day. I'm gonna go, Mr. Casares, Mr. Casares, and I hung up on the lawyer. And about 2 weeks later, my dad was notified, and he got it in writing from his lawyer that the case was dropped. And my dad called everybody, told everybody, and he was supposed to get his money back. I don't know, or he was supposed to pay. I know there was a retainer fee, a consultation fee, or something. I said, well, the consultation go over the legal obligations. My dad's like, no, he cussed and swear a lot, and it wasn't a happy day, but when they notified him that the suit was dropped, the family, he had invited everybody over and had, I guess, food and liquor or whatever, and I didn't go. It was a rather private issue, personal issue. I told my dad, we'll save it for when it's just me and you. And about a month later, we went to his old stomping grounds over in Chicago. It's over on Cermak and Marshall Boulevard. And boy, he laughed and laughed, and I had everybody laughing. About how I talked to a lawyer, and just talking to the lawyer, the case was dropped. And he could not stop laughing when he was telling them about how I was asking the lawyer if he was Mr. Deco. Yeah, something in Spanish. Yeah, pinche Mr. Deco, Mr. Ben Deco. Everybody was laughing and offering to buy me drinks, and I didn't drink. I wish I did at that time, but they were having. My dad had a great time. Talking about how I talked to his lawyer and had the whole thing dropped. I just talked to his lawyer using the rules. I mean, these are laws, people. These are laws. Okay. So let's go to the rules of professional conduct real quick before I end this, okay? We could use the ABA. Every state rules are model. That's why they call this the model rule of professional conduct. Okay, this is the model, and every state is required to use it. Okay, and they can enhance on it, build on it. They can't take away from it. And it tells you that in the preamble. They can add to it, which is in the interest of the public, and removing anything, as I told you, that's in the interest of the bar, because I've been using this so long. Okay, diligence. Okay, it's just a short, a lawyer shall act with reasonable diligence and promptness in representing a client. You ever know a lawyer to be diligent? If he's not diligent, he's certainly not what? A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. Communications. A lawyer shall promptly inform a client of any decision or circumstance with respect to which the client's informed consent. Remember I keep telling you about informed consent? There used to be a clause in the rules of professional conduct between the preamble and the rules, I think. There was it was maybe a paragraph or two about informed consent. Basically, it said you need reasonable information to make an informed decision and give informed consent, and that's a legal requirement. Informed consent. Okay, that is a legal requirement. That is a legal term. And even same with doctors, they can't do anything without getting consent from you. Properly inform a client of any decision or circumstance with respect to which the client's informed consent is defined in Rule 1.0 is required by these rules. See? And it'll tell you in here. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. Keep with the client reasonably informed about the status of the matter. And they never did that for me. My workman's comp, Social Security, whatever I took a lawyer to task. None of this happened. Consult with the client about any limitations of the lawyer's conduct when a lawyer knows that the client expects assistance not permitted by the rules of professional conduct. Basically, you can't tell him he's not to do something that would violate the rules of professional conduct. You say, no, that's breaking the law. Okay. Lawyer shall explain the matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Okay, so that says a lot about communication, doesn't it? Okay, so that's why I was, showing you that I gave you the short terms where the lawyer knew exactly what I was talking about. Client with a diminished capacity. When a client's capacity to make adequate considered conditions in connection with representation is diminished, well, you don't have the legal knowledge, or the reasonable knowledge, which is legal knowledge, to make an informed decision, to give informed consent. I mean, your mental impairment is you lack the education, the needed skill to combat your ineffective, destructive, and defective assistance of counsel. That's where deprivation of rights starts. And it's the opposing party and the judge's job to make sure your lawyer does this. And they're supposed to make sure, your lawyer's supposed to make sure, everybody's supposed to make sure everybody does all this, okay? So if your lawyer's supposed to do it, in fairness, opposing party, they're supposed to do it too. Duties to prospective client. So if you want to talk to a lawyer, or they want to, talk to you, consultation fee, advisory, whatever fee it is. So before you see a lawyer for anything, a lot of times people get sued, lack of meritorious claims and contentions called slap suits. A lawyer shall not bring or defend a proceeding or assert a convert issue that is therein unless there is a basis for law or fact for doing so. It is not frivolous which includes good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that can result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. And that's a requirement, that every element of the case be established. They can't just go in there and say, well, I heard, somebody said, point the finger. No, it has to be proven. That comes in the requirements of innocent until proven guilty. But you know, if you're involved in any kind of case, not just a criminal case, you're always guilty until proven innocent. Okay? But the lack of meritorious claims to contention, so you're really going to want to use that no matter what court you're in. I've been trying to instruct a lot of people about that when it comes to probate court, conservatorship, when it comes to family court, when they take your kids away. They're taking kids away just by somebody making a Karen call. Oh, well, somebody called, and what are we gonna do? But see, that just keeps that's what keeps them in the court. Expediting litigation. Lawyers shall make reasonable efforts to expedite litigation consistent with the interest of the client. That's you. That's you, okay? Fairness to the opposing party. Remember I mentioned that. A lawyer shall not unlawfully obstruct another party's access to evidence, unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do any such act. Falsify evidence, counsel, or assist a witness to testify falsely, or offer an inducement to a witness, like money or sex or, drugs. It is prohibited by law. Knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on assertion no value obligation exists. In pretrial procedure, like a probable cause hearing or a preliminary hearing, in a pretrial procedure, make frivolous discovery requests or failure to make reasonable, diligent effort to comply with legal proper discovery requests by an opposing party. So when you come into court, anybody comes into court and makes any charges against you, and you appear, whether it be criminal court or civil court, before this proceeding can take place. Okay. They must comply with legal proper discovery requests. Okay. And there has to be some ground, something to prove that this case should go beyond probable cause or preliminary hearing. They have to establish probable cause, okay? And if they can't establish probable cause, that's making a fraudulent and frivolous claim, which is prohibited by law in every court of law. But they'll let it go. So don't. The only way it's not going to happen is if you bring this to your court. Hey, let's do this, all right? This is your job. This is your constitutional duty. You took the oath to do this, when you took oath to the Constitution, effective assistance of counsel, the requirement of the Sixth Amendment, and that goes for the rules of professional conduct. Code of Judicial Conduct are what describes effective assistance of counsel, the requirements of all lawyers and judges. Request a person other than direct client to refrain from voluntarily giving relevant information another party unless the person is a relative or employee or other agent client, and the lawyer reasonably believes that the person's interest will not be adversely affected by refraining from giving such information. Fairness to the opposing party, impartiality towards the quorum. See, people, these are a lot of the videos I use these terms like impartiality and decorum of the tribunal. See, this is what it means. See, a lawyer or a judge, when I say it, they'll know. But they know you don't know So they'll talk to me like I'm an idiot, and you'll sit there and laugh at them and laugh at me with them because you don't know what it means. That's acting under the color of law. They're counting on your lack of knowledge. That's why they love the uneducated or uneducated. Because then you don't know that you're living under the color of law. Communication involves misrepresentation, coercion, duress, or harassment. Engage in conduct intended to disrupt a tribunal. Lawyers as a witness, special responsibilities as a prosecutor. Remember I told you about that. And prosecute a criminal case. Refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. That's why I always tell people, ask for a probable cause hearing, because nobody's going to offer it to you. That's the state's attorney's job, to make sure that there's probable cause, and if there isn't, they're supposed to pay. Officer, this is nothing but legal harassment. You locked this guy up just so he'll spend the night in jail and come here. Now I got to throw this out because there was no probable cause for arrest. That's legally a strike against you. See, you took the oath to the Constitution like I took the oath to the Constitution. It's our constitutional duty to make sure that nobody ever gets arrested without probable cause. Not just because your little feelings get hurt, or you got a hangover, or you want to rush off to do that next bump. Whatever. All right, no. It's not just the prosecutor's job to establish probable cause. As you well know, out on the streets, they must establish probable cause. It's a law for all public servants. Not to seek or obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing or what's called a probable cause hearing. Make timely disclosure to defense all evidence or information known to the prosecutor that tends to negate the guilt, showing you're innocent, of the accused or mitigates the offense and connection with sentencing, disclose the offense and the tribunal, all unprivileged mitigating information known to the prosecutor, except when the prosecutor believed to be responsible. Okay. But it tells you a lot of things they can't do, and they'll do it anyway. Okay, so let's go down here. When I told you my other video, people ask me a lot of times if they need to find, they got exculpatory evidence, and they need to find a lawyer to help them overturn his case. If I know of a good lawyer, and I've only met one lawyer, Mr. Thomas Bennett, that ever sat down and spoke openly and clearly and jovially about the rules and the codes. We laughed and joked about it, and but only one lawyer I ever known that did, and he didn't fire or quit. He didn't quit on me either. When a prosecutor knows of new credible material evidence creating new and credible likelihood that a convicted defendant did not commit or offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to the appropriate court and authority. If the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay. Undertake further investigation, make reasonable efforts to cause an investigation, which is investigation of conspiracy against rights under the color of law. Determine whether the defendant was convicted of offense determined the defendant did not commit. When the prosecutor knows of clear and convincing evidence establishing the defendant in the prosecutor's jurisdiction was convicted of offense the defendant did not commit, the prosecutor shall seek to remedy the conviction. Lovely, isn't it? It's good to know. Truthful statements to others. Okay. Lying, it's called disinformation. That's illegal. There's penalties for disinformation. And the rule of professional conduct tells you what? Truthful in statements to others. And of course, representing client or lawyer shall not knowingly make a false statement or material fact or law to a third person, or fail to disclose material fact to a third person when disclosure is necessary, to avoid assisting of criminal or fraudulent act by a client unless disclosure is prohibited by Rule 1.6. Okay? To avoid assisting a criminal or fraudulent act by a client. They can't do that. But you see it happens all the time. Responsibility of subordinate lawyer. It says here that, they do what they do because they're taking orders, from higher ups. But still that's violating oath and it's illegal. They can't just say, I was doing my job. That's what whistleblowers complaints are about. You took an oath to make sure that nobody violates the oath. And nobody can order you violate the oath. It's illegal. Unlawful orders. Giving unlawful orders. That's illegal. But they'll do it anyways, because if they don't do it, then they'll lose their job. And then they'll have to file a whistleblower complaint. And then they'll be blackballed from, being a lawyer. No judge will ever see anything their way. They're just on a professional blacklist. That's why there's no serpicals in the legal arena. Accepting appointments. Communications concerning a lawyer's service. They'll lie about that, so you might want to read that. Maintaining the integrity of the profession. Remember, I put that in my complaint there, maintaining the integrity of the profession. That's mandatory. That's breaking law if you're not. Reporting professional misconduct. It's mandatory. Reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of rules of professional conduct or raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer, or other respects, shall inform the appropriate professional authority. A lawyer who knows that a judge has committed a violation applicable rules of the judicial conduct that raises substantial question as to the judge's fitness for office shall inform the appropriate authority. The rules does not require disclosure of information otherwise protected by Rule 1.6 or information gained by a lawyer or judge while participating in approved lawyer's assistance program. But nobody's telling you any of this. That's misconduct. Professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so through the acts of another, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer or other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Engage in conduct that is prejudicial to the administration of justice. State or imply the ability to influence improperly a government agency or official to achieve results by means that violate the rules of professional conduct or other law. These are laws, people. It says, or other law. Knowingly assist the judge or judicial officer in conduct is in violation applicable rules of the judicial conduct or other law. And since nobody's doing this or reporting anybody, that's conspiracy against rights under the color of law. Engage in conduct the lawyer knows or reasonably shown that is known as harassment or discrimination. Like when a lawyer says, I'll sue you and I'll take this and I'll take that without probable cause. There has to be some cause, probable cause for them to do it outside of them being a lawyer and you're hurting their egotistical feelings. I'm a lawyer. I can file litigation, and you're going to have to get a lawyer that's going to have to. No, you're a lawyer. I mean, you think you're going to have to get a lawyer, and they're going to have to counteract and react to their action, and it's going to go back and forth for a long time. And that lawyer you're hiring is not going to tell you, hey, this is just theater here. So that way, I get money, he gets money, and either way this goes, he's not going to win, but we're going to string this out so long. I'm like, I don't know, maybe they're giving him a cut. Okay, but a lot of people get mad at me. The last gentleman I was having one of those, where a lot of people are on the phone and they wanted to hang up on me or something because they wanted to talk about the case, and I'm trying to tell them, no, they want to talk about the time limit and, about expediting litigation and competence. They were talking about calling this guy competent and incompetent. I says, and that's against the law. And so everything they're complaining about, I'm telling them it's here in the rules of professional conduct, but they didn't want to talk about that. They wanted to talk about their case and how all the rules and the codes are being violated. Okay, but see, these are legal responsibilities of all lawyer judges in a court of law. Everybody's supposed to make sure everybody's doing this. And if somebody isn't, then it's everybody else's job to report that misconduct. It says right here. Okay. Reporting professional misconduct. Any misconduct, 8.4. Okay. 8.3, it says reporting that is mandatory, reporting professional misconduct. That's how we maintain the integrity of the profession. Okay. So this one guy laughed at me because I told him, it's up to you. I don't know exactly. He wanted to tell me about his case. I told him, no, you want to go over your case, but first go over the rules, and then use your own magic. And what magic is that? Because every time you look at a rule, click on it to open it, and then it'll tell you what you can say. And you could use it word for word to the letter. What are they going to do, cite you for plagiarism? Tell them, no, that's not plagiarism. That's homage. What are they going to do, call it cultural appropriation? Because it is for them. When it comes to the legal system, it's society within a society. Nepotism reigns supreme. When we traded off the monarchy for, a political system, we only changed who's in charge of the hierarchy. We didn't get rid of the hierarchy. Our politicians are being treated as a monarchy if you look at it. I mean, they're public servants, and nobody's living up to the oath. Nobody's living up to the basic obligations of public service. None of that. There's a whole lot I talk about. Okay. But how about we start talking to everybody, about maintaining the integrity of the profession. And remember, that was part of what I put in that 500-word composition to forward to the FBI, DOJ, disciplinary boards for judges or lawyers, the ABA, your state bar association, wherever there's a complaint to be filed, file it. Take every avenue, every freaking avenue. Put everybody to task. They all know this is happening to you, but nobody will do anything to stop it unless you file a complaint. Everybody knows. And I'm showing you. It's on the internet. Everything I do, I go to places like this and read it to you. That's all. Twice on TikTok, lawyers jumped in. One went to advertisers. He sues for this shit, and they'll help you get money out of it. But he's adding to the conspiracy against rights. You know, in a perfect world, everybody would live up to the oath and what's required by that oath. And that's what I show you on my page, Legal Reform. All the requirements of that oath by all your public servants, and how nobody's doing any of that. And I need your help. I need your help. You know. My migraines have been kicking my ass for a couple of weeks. I haven't been able to say much for long. And I've been fighting nausea and a lot of really other bad feelings. And those migraines get really bad. It feels like my brain is in a vice, like it's imploding and exploding. So I can't think properly. So I have these sudden spurts of non-anxiety. It allows me to talk to you. All right, today is December 25th. Merry Christmas to those that celebrate. I do. And I'm sitting here with everybody close to me. Say hello, everybody. Everybody's waving. No, I'm just kidding. There's nobody here. I'm by myself. I'm a recluse. What people nowadays call an introvert. You know, most people wouldn't understand what I talk about, and what I do, and why I do it. You know. It's just because I read the Constitution, the Declaration of Independence. I read the Magna Carta. I read the history of the Magna Carta. You know. Maybe it's because I learned so young that I learned the requirements of a patriot to see to it that all our public lives up to the oath. Do you remember what the Declaration of Independence says about usurpers? Those seek to deprive of life, liberty, and pursuit of happiness. These are your usurpers. Anybody and everybody not doing this. This is the law. A lawyer's responsibilities, his constitutional duties, your constitutional right. He is a trustee of the public trust. Any violation disqualifies any public service, any public servant from any public service when they violate the oath and everything required by that oath, from the police to the president. That's what I do on legal reform. I want you to know your rights. You don't. I really don't. You don't need to get to know me. I'm really not that type of person. You know. But what you need to get to know is your birthrights. All right. That's all I talk about. Your birthrights as a citizen. I'm a peace and love to you. May your Creator always be with you and rain many blessings. May this be one of many. God bless, good night, Merry Christmas, and a Happy New Year. Love you, one and all.